Please be seated. The sitting is open. The court meets today to deliver its decision on the request for the indication of provisional measures submitted by the Gambia in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide. Judge Sebutinde, who duly participated both in the deliberations and in the final vote, is, for reasons made known to me, unable to take her seat on the bench today. I would recall that on 11 November 2019, the Gambia filed in the registry of the court an application instituting proceedings against the Republic of the Union of Myanmar with regard to alleged violations of the Convention on the Prevention and Punishment of the Crime of Genocide, which I will refer to as the Genocide Convention. The application contained a request for the indication of provisional measures submitted with reference to Article 41 of the statute and to Articles 73, 74, and 75 of the Rules of Court. In accordance with the usual practice, I shall not read the introductory paragraphs of the order, which set out the procedural history of the case. I shall also omit or summarize some other paragraphs. I shall accordingly begin the reading of the order at paragraph 14. In its application, the Gambia seeks protection for, and I quote, all members of the Rohingya group who are in the territory of Myanmar as members of a protected group under the Genocide Convention, end of quote. The court, in this respect, wishes to point out that the references in the order to the Rohingya should be understood as references to the group that self-identifies as the Rohingya group and that claims a long-standing connection to Rakhine State, which forms part of the Union of Myanmar. The court recalls that it may indicate provisional measures only if the provisions relied on by the applicant appear prima facie to afford a basis on which its jurisdiction could be founded, but need not satisfy itself in a definitive manner that it has jurisdiction as regards the merits of the case. In the present case, the Gambia seeks to found the jurisdiction of the court on Article 36, paragraph 1 of the statute of the court and on Article 9 of the Genocide Convention. The court must therefore first determine whether those provisions prima facie confer upon its jurisdiction to rule on the merits of the case, enabling it, if the other necessary conditions are fulfilled, to indicate provisional measures. The Gambia and Myanmar are parties to the Genocide Convention. Myanmar deposited its instrument of ratification on 14 March 1956 without entering a reservation to Article 9, but making reservations to Articles 6 and 8. The Gambia acceded to the Convention on 29 December 1978 without entering any reservation. Article 9 of the Genocide Convention makes the court's jurisdiction conditional on the existence of a dispute relating to the interpretation, application, or fulfillment of the Convention. A dispute between states exists where they hold clearly opposite views concerning the question of the performance or non-performance of certain international obligations. The claim of one party must be positively opposed by the other. The court cannot, however, limit itself to noting that one of the parties maintains that a dispute exists and the other denies it. Since the Gambia has invoked as a basis of the court's jurisdiction the compromissory clause in an international convention, the court must ascertain whether the acts complained of by the applicant are capable of falling within the provisions of that instrument, and whether, as a consequence, the dispute is one which the court has jurisdiction ratione materiae to entertain. The court also recalls that, in principle, the date for determining the existence of a dispute is the date on which the application is submitted to the court. The court recalls Myanmar's contention that in bringing before the court its claims based on alleged violations of the Genocide Convention, the Gambia acted as a proxy for the Organization of Islamic Cooperation in circumvention of Article 34 of the statute. The court noticed that the applicant instituted proceedings in its own name, and that it maintains that it has a dispute with Myanmar regarding its own rights under the convention. In the view of the court, the fact that the Gambia may have sought and obtained the support of other states or international organizations in its endeavor to seize the court does not preclude the existence between the parties of a dispute relating to the Genocide Convention. Turning to the question whether there was a dispute between the parties at the time of the filing of the application, the court recalls that for the purposes of deciding this issue, it takes into account, in particular, any statements or documents exchanged between the parties, as well as any exchanges made in multilateral settings. In so doing, the court pays special attention to the author of the statement or document, their intended or actual addressee, and their content. The existence of a dispute is a matter for objective determination by the court. It is a matter of substance and not a question of form or procedure. The court notes that in a report published on 8 August 2019, the Independent International Fact-Finding Mission on Myanmar, established by the Human Rights Council of the United Nations, and I will refer to it as the Fact-Finding Mission, affirmed its previous conclusion, I quote, that Myanmar incurs state responsibility under the prohibition against genocide, end of quotation. It welcomed in the report the efforts of the Gambia, Bangladesh, and the Organization of Islamic Cooperation to pursue a case against Myanmar before the court under the Genocide Convention. On 26 September 2019, the Gambia stated during the general debate of the 74th session of the General Assembly of the United Nations that it was ready to lead concerted efforts to take the Rohingya issue to the International Court of Justice. Myanmar addressed the General Assembly 2 days later, characterizing the fact-finding mission report as, I quote, biased and flawed, based not on facts but on narratives, end of quotation. In the court's view, This statement is made by the parties before the United Nations General Assembly suggests the existence of a divergence of views concerning the events which allegedly took place in the Rakhine State in relation to the Rohingya. In addition, the court takes into account the Gambia's note verbal sent to Myanmar on 11 October 2019, in which the Gambia, referring to the reports of the fact-finding mission, wrote that, and I quote, that it understood Myanmar to be in ongoing breach of its obligations under the Genocide Convention and under customary international law, and insisted that Myanmar take all necessary actions to comply with these obligations, end of quotation. The court observes that this note verbal specifically referred to the reports of the fact-finding mission and indicated the Gambia's opposition to the views of Myanmar, in particular as regards the latter's denial of its responsibility under the Convention. In light of the gravity of the allegations made therein, the court considers that the lack of response may be another indication of the existence of a dispute between the parties. As to whether the acts complained of by the applicant are capable of falling within the provisions of the Genocide Convention, the court recalls that the Gambia contends that Myanmar's military and security forces and persons or entities acting on its instructions or under its direction and control have been responsible, inter alia, for killings, rape and other forms of sexual violence, torture, beatings, cruel treatment, and for the destruction or denial of access to food, shelter, and other essentials of life, all with the intent to destroy the Rohingya group in whole or in part. In the Gambia's view, these acts are all attributable to Myanmar, which it considers to be responsible for committing genocide. The Gambia contends that Myanmar has also violated other obligations under the Genocide Convention. The court notes that Myanmar, for its part, denied that it has committed any of the violations of the Genocide Convention alleged by the Gambia, arguing in particular the absence of any genocidal intent. For the purposes of the present proceedings, the court is not required to ascertain whether any violations of Myanmar's obligations under the Genocide Convention have occurred. Such a finding, which notably depends on the assessment of the existence of an intent to destroy, in whole or in part, the group of the Rohingya as such, could be made by the court only at the stage of the examination of the merits of the present case. What the court is required to do at the stage of making an order on provisional measures is to establish whether the acts complained of by the Gambia are capable of falling within the provisions of the Genocide Convention. In the court's view, at least some of the acts alleged by the Gambia are capable of falling within the provisions of the Convention. The court finds, therefore, that the aforementioned elements are sufficient at the current stage to establish prima facie the existence of a dispute between the parties relating to the interpretation, application, or fulfillment of the Genocide Convention. The court now turns to Myanmar's submission, according to which the Gambia cannot validly seize the court as a result of Myanmar's reservation to Article 8 of the Genocide Convention. In this connection, the court recalls that Article 8 of the Genocide Convention provides as follows: any contracting party may call upon the competent organs of the United Nations to take such action under the Charter of the United Nations as they consider appropriate for the prevention and suppression of acts of genocide or any other acts enumerated in Article 3. The court considers that although the terms competent organs of the United Nations under Article 8 are broad and may be interpreted as encompassing the court within their scope of application, other terms used in Article 8 suggest a different interpretation. In particular, the court noticed that this provision only addresses in general terms the possibility for any contracting party to call upon the competent organs of the United Nations to take action which is appropriate for the prevention and suppression of acts of genocide. It does not refer to the submission of disputes between contracting parties to the Genocide Convention to the court for adjudication. This is a matter specifically addressed in Article 9 of the Convention, to which Myanmar has not entered any reservation. Article 8 and Article 9 of the Convention can therefore be said to have distinct areas of application. It is only Article 9 of the Convention which is relevant to the saisine of the court in the present case. Myanmar's reservation to Article 8 of the Genocide Convention thus does not appear to deprive the Gambia of the possibility to seize the court of a dispute with Myanmar under Article 9 of the Convention. In light of the foregoing, the court concludes that prima facie it has jurisdiction pursuant to Article 9 of the Genocide Convention to deal with the case. Given this conclusion, the court considers that it cannot accede to Myanmar's request that the case be removed from the general list for manifest lack of jurisdiction. The court now turns to the question of the standing of the Gambia, which was raised by Myanmar during the hearing. In this connection, it is recalled that in the advisory opinion of the court on reservations to the Convention on the Prevention and Punishment of the Crime of Genocide, the court observed that in such a convention, the contracting states did not have any interests of their own. They merely had one and all a common interest, namely the accomplishment of those high purposes which are the raison d'etre of the Convention. The court observes that in view of their shared values, all the states parties to the Genocide Convention have a common interest to ensure that acts of genocide are prevented and that if they occur, their authors do not enjoy impunity. That common interest implies that the obligations in question are owed by any state party to all the other states parties to the Convention. In its judgment in the case concerning questions relating to the obligation to prosecute or extradite Belgium versus Senegal, the court observed that the relevant provisions in the Convention Against Torture were similar to those in the Genocide Convention. The court held that these provisions generated obligations which may be defined as obligations erga omnes partes, in the sense that each state party has an interest in compliance with them in any given case. It follows that any state party to the Genocide Convention, and not only a specially affected state, may invoke the responsibility of another state party with a view to ascertaining the alleged failure to comply with its obligations erga omnes partes and to bring that failure to an end. The court concludes that the Gambia has prima facie standing to submit to it the dispute with Myanmar on the basis of alleged violations of obligations under the Genocide Convention. A second condition for the indication of provisional measures by the court concerns the rights whose protection is sought and the link between such rights and the measures requested. The court recalls that the power it holds to indicate provisional measures under Article 41 of the statute has at its object the preservation of the respective rights claimed by the parties in a case, pending its decision on the merits thereof. It follows that the court must be concerned to preserve by such measures the rights which may subsequently be adjudged by it to belong to either party. Therefore, the court may exercise this power only if it is satisfied that the rights asserted by the party requesting such measures are at least plausible. At the current stage of the proceedings, however, the court is not called upon to determine definitively whether the rights which the Gambia wishes to see protected exist. It need only decide whether the rights claimed by the Gambia on the merits and for which it is seeking protection are plausible. Moreover, a link must exist between the rights whose protection is sought and the provisional measures being requested. The court observes that in accordance with Article 1 of the Convention on Genocide, all states parties thereto have undertaken to prevent and to punish the crime of genocide. Article 2 of the Convention provides that, and I quote, genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnical, racial, or religious group as such. A, killing members of the group. B, causing serious bodily or mental harm to members of the group. C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. D, imposing measures intended to prevent births within the group. E, forcibly transferring children of the group to another group. End of quotation. Pursuant to Article 3 of the Genocide Convention, the commission of the following acts, other than genocide itself, are also prohibited by the Convention: conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, and complicity in genocide. The obligation to prevent and punish genocide set out in Article 1 of the Convention is supplemented by the distinct obligations which appear in the subsequent articles, especially those in Articles 5 and 6, requiring the enactment of the necessary legislation to give effect to the provisions of the Convention, as well as the prosecution of persons charged with such acts, insofar as these provisions concerning the duty to punish also have a deterrent and therefore a preventive effect or purpose, they too meet the obligation to prevent genocide. The Court further observes that the provisions of the Convention are intended to protect the members of a national, ethnical, racial, or religious group from acts of genocide or any other punishable acts enumerated in Article 3. It considers that there is a correlation between the rights of members of groups protected under the Genocide Convention, the obligations incumbent on state parties thereto, and the right of any state party to seek compliance therewith by another state party. In the Court's view, the Rohingya in Myanmar appear to constitute a protected group within the meaning of Article 2 of the Genocide Convention. In the present case, the Court notes that at the hearings, Myanmar, referring to what it characterizes as clearance operations carried out in Rakhine State in 2017, stated as follows, that it cannot be ruled out that disproportionate force was used by members of the defense services in some cases, in disregard of international humanitarian law, or that they did not distinguish clearly enough between Arakan Rohingya Salvation Army fighters and civilians, and that there may also have been failures to prevent civilians from looting or destroying property after fighting or in abandoned villages. The Court also noticed that the United Nations General Assembly, in its resolution 73/264, adopted on 22 December 2018, condemned, and I quote, all violations and abuses of human rights in Myanmar as set out in the report of the fact-finding mission, including the widespread, systematic, and gross human rights violations and abuses committed in Rakhine State, including the presence of elements of extermination and deportation and the systematic oppression and discrimination that the fact-finding mission concluded may amount to persecution and to the crime of apartheid. End of quotation. The General Assembly also strongly condemned the grossly disproportionate response of the military and the security forces and deplored the serious deterioration of the security, human rights, and humanitarian situation, and the exodus of more than 723,000 Rohingya Muslims and other minorities to Bangladesh, and the subsequent depopulation of northern Rakhine State. The Assembly called upon the Myanmar authorities to ensure that those responsible for violations of international law, including human rights violations and abuses, are held accountable and removed from positions of power. In this connection, the Court recalls that the fact-finding mission to which the General Assembly refers in its aforementioned resolution states in its report of 12 September 2018, that it had, and I quote, reasonable grounds to conclude that serious crimes under international law had been committed that warranted criminal investigation and prosecution, including the crime of genocide against the Rohingya in Myanmar. The fact-finding mission concluded, and I quote, on reasonable grounds, the factors allowing the inference of genocidal intent were present. The fact-finding mission reiterated its conclusions based on further investigations in its report of 8 August 2019. The court noticed that the fact-finding mission in its 2018 detailed findings also asserted, based on its overall assessment of the situation in Myanmar since 2011, and particularly in Rakhine State, that the extreme levels of violence perpetrated against the Rohingya in 2016 and 2017 resulted from, and I quote, the systemic oppression and persecution of the Rohingya, end of quote. In view of the function of provisional measures, which is to protect the respective rights of either party, pending the final decision of the court does not consider that the exceptional gravity of the allegations is a decisive factor, warranting, as argued by Myanmar, the determination at the present stage of the proceedings of the existence of a genocidal intent. In the court's view, all the aforementioned facts and circumstances are sufficient to conclude that the rights claimed by the Gambia and for which it is seeking protection are plausible. These are namely the right of the Rohingya group in Myanmar and of its members to be protected from acts of genocide and related prohibited acts mentioned in Article 3, and the right of the Gambia to seek compliance by Myanmar with its obligations not to commit and to prevent and punish genocide in accordance with the Convention. The court now turns to the issue of the link between the rights claimed and the provisional measures requested. The court considers that by their very nature, the first 3 provisional measures sought by the Gambia are aimed at preserving the rights it asserts on the basis of the Genocide Convention in the present case, namely the right of the Rohingya group in Myanmar and of its members to be protected from acts of genocide and other acts mentioned in Article 3, and the right of the Gambia to have Myanmar comply with its obligations under the Convention to prevent and punish acts identified and prohibited under Articles 2 and 3 of the Convention, including by ensuring the preservation of evidence. As to the 4th and 5th provisional measures requested by the Gambia, the question of their link with the rights for which the Gambia seeks protection does not arise. As to the 6th provisional measure requested by the Gambia, the court does not consider that its indication is necessary in the circumstances of the case. The court concludes, therefore, that a link exists between the rights claimed and some of the provisional measures being requested by the Gambia. The court, pursuant to Article 41 of its statute, has the power to indicate provisional measures when irreparable prejudice could be caused to rights which are the subject of judicial proceedings, or when the alleged disregard of such rights may entail irreparable consequences. However, the power of the court to indicate provisional measures will be exercised only if there is urgency, in the sense that there is a real and imminent risk that irreparable prejudice will be caused before the court gives its final decision. The condition of urgency is met when the act is susceptible of causing irreparable prejudice can occur at any moment before the court makes a final decision on the case. The court must therefore consider whether such a risk exists at the current stage of the proceedings. The court is not called upon, for the purposes of its decision on the request for the indication of provisional measures, to establish the existence of breaches of the Genocide Convention. It has to determine whether the circumstances require the indication of provisional measures for the protection of the rights under this instrument. It cannot, at the current stage, make definitive findings of fact, and the right of each party to submit arguments in respect of the merits remains unaffected by the court's decision on the request for the indication of provisional measures. The court recalls that, as underlined in the General Assembly Resolution 961 of 11 December 1946, genocide is a denial of the right of existence of entire human groups, as homicide is the denial of the right to live of individual human beings. Such denial of the right of existence shocks the conscience of mankind, results in great losses to humanity in the form of cultural and other contributions represented by these human groups, and is contrary to moral law and to the spirit and aims of the United Nations. The court has observed in its advisory opinion on reservations to the Convention on the Prevention and Punishment of the Crime of Genocide that the Genocide Convention was manifestly adopted for a purely humanitarian and civilizing purpose, since its object, on the one hand, was to safeguard the very existence of certain human groups, and on the other, to confirm and endorse the most elementary principles of morality. In view of the fundamental values sought to be protected by the Genocide Convention, the court considers that the rights in question in these proceedings, in particular the right of the Rohingya group in Myanmar and of its members to be protected from killings and other acts threatening their existence as a group, are of such a nature that prejudice to them is capable of causing irreparable harm. The court notes that the reports of the fact-finding mission have indicated that since October 2016, the Rohingya in Myanmar have been subjected to acts which are capable of affecting their right of existence as a protected group under the Genocide Convention. As indicated in Resolution 74/246, adopted by the General Assembly on 27 December 2019, this has caused almost 744,000 Rohingya to flee their homes and take refuge in neighboring Bangladesh. According to the 2019 report of the fact-finding mission on Myanmar, approximately 600,000 Rohingya remained in Rakhine State as of September 2019. The court is of the opinion that the Rohingya in Myanmar remain extremely vulnerable. In this respect, the court notes that in its resolution 74/246 of 27 December 2019, the General Assembly reiterated, and I quote, its grave concern that in spite of the fact that Rohingya Muslims lived in Myanmar for generations prior to the independence of Myanmar, they were made stateless by the enactment of the 1982 citizenship law and were eventually disenfranchised in 2015 from the electoral process. End of quotation. The court further takes note of the detailed findings of the fact-finding mission on Myanmar submitted to the Human Rights Council in September 2019, which refer to the risk of violations of the Genocide Convention, and in which, I quote, it is concluded on reasonable grounds that the Rohingya people remain at serious risk of genocide under the terms of the Genocide Convention. End of quotation. The court takes note of the statement of Myanmar during the oral proceedings that it is currently engaged in repatriation initiatives to facilitate the return of Rohingya refugees present in Bangladesh, and that it intends to promote ethnic reconciliation, peace and stability in Rakhine State, and to make its military accountable for violations of international humanitarian and human rights law. However, in view of the court, these steps do not appear sufficient in themselves to remove the possibility that acts causing irreparable prejudice to the rights invoked by the Gambia for the protection of the Rohingya in Myanmar could occur. In particular, the court notes that Myanmar has not presented to the court concrete measures aimed specifically at recognizing and ensuring the right of the Rohingya to exist as a protected group under the Genocide Convention. Moreover, the court cannot ignore that the General Assembly has, as recently as on 27 December 2019, expressed its regret that, and I quote, the situation has not improved in Rakhine State to create the conditions necessary for refugees and other forcibly displaced persons to return to their places of origin voluntarily, safely, and with dignity. End of quotation. The General Assembly reiterated at the same time its deep distress at reports that unarmed individuals in Rakhine State have been and continue to be subjected to the excessive use of force and violations of human rights and international humanitarian law by the military and security and armed forces, including extrajudicial, summary, or arbitrary killings, systematic rape and other forms of sexual and gender-based violence, arbitrary detention, enforced disappearance, and government seizure of Rohingya lands from which Rohingya Muslims were evicted and their homes destroyed. Finally, the court observes that irrespective of the situation that the Myanmar government is facing in Rakhine State, including the fact that there may be an ongoing internal conflict between armed groups and the Myanmar military, and that security measures are in place, Myanmar remains under the obligation incumbent upon it as a state party to the Genocide Convention. The Court recalls that in accordance with the terms of Article 1 of the Convention, state parties expressly confirmed their willingness to consider genocide as a crime under international law which they must prevent and punish independently of the context of peace or of war in which it takes place. The context invoked by Myanmar does not stand in the way of the Court's assessment of the existence of a real and imminent risk of irreparable prejudice to the rights protected under the Convention. In light of the aforementioned considerations, the Court finds that there is a real and imminent risk of irreparable prejudice to the rights invoked by the Gambia as specified by the Court. From all of the foregoing considerations, the Court concludes that the conditions required by its statute for it to indicate provisional measures are met. It's therefore necessary, pending its final decision, for the Court to indicate certain measures in order to protect the rights claimed by the Gambia as identified by the Court. The Court recalls that it has the power under its statute, when a request for provisional measures has been made, to indicate measures that are in whole or in part other than those requested. Article 75, paragraph 2 of the Rules of Court specifically refers to this power of the Court. The Court has already exercised this power in the past. In the present case, having considered the terms of the provisional measures requested by the Gambia and the circumstances of the case, the Court finds that the measures to be indicated need not be identical to those requested. Bearing in mind Myanmar's duty to comply with its obligations under the Genocide Convention, the Court considers that with regard to the situation described earlier, Myanmar must, in accordance with its obligations under the Convention and in relation to the members of the Rohingya group in its territory, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Genocide Convention, in particular, A, killing members of the group, B, causing serious bodily or mental harm to the members of the group, C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D, imposing measures intended to prevent births within the group. Myanmar must also, in relation to the members of the Rohingya group in its territory, ensure that its military, as well as any irregular armed units which may be directed or supported by it, and any organizations and persons which may be subject to its control, direction, or influence, do not commit acts of genocide, conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, or complicity in genocide. The Court is also of the view that Myanmar must take effective measures to prevent the destruction and ensure the preservation of any evidence related to allegations of acts within the scope of Article 2 of the Genocide Convention. Regarding the provisional measure requested by the Gambia, that each party shall provide a report to the court on all measures taken to give effect to its order, the court recalls that it has the power reflected in Article 78 of the Rules of Court to request the parties to provide information on any matter connected with the implementation of any provisional measures it has indicated. In view of the specific provisional measures it has decided to indicate, the court considers that Myanmar must submit a report to the court on all measures taken to give effect to this order within 4 months, as from the date of this order, and thereafter every 6 months, until a final decision on the case is rendered by the court. Every report so provided shall then be communicated to the Gambia, which shall be given the opportunity to submit to the court its comments thereon. The Gambia has further requested the court to indicate measures aimed at ensuring the non-aggravation of the dispute with Myanmar. In this respect, the court recalls that when it is indicating provisional measures for the purpose of preserving specific rights, it also possesses the power to indicate additional provisional measures with a view to preventing the aggravation or extension of the dispute whenever it considers that the circumstances so require. However, in the circumstances of the present case, and in view of the specific provisional measures it has decided to indicate, the court does not deem it necessary to indicate an additional measure relating to the non-aggravation of the dispute between the parties. The court reaffirms that its orders on provisional measures under Article 41 of the statute have binding effect and thus create international legal obligations for any party to whom the provisional measures are addressed. The court further reaffirms that the decision given in the present proceedings in no way prejudges the question of the jurisdiction of the court to deal with the merits of the case or any questions relating to the admissibility of the application or to the merits themselves. It leaves unaffected the right of the governments of the Gambia and Myanmar to submit arguments and evidence in respect of those questions. For these reasons, the court indicates the following provisional measures. 1. Unanimously, the Republic of the Union of Myanmar shall, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, in relation to the members of the Rohingya group in its territory, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Convention, in particular, killing members of the group, causing serious bodily or mental harm to the members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and imposing measures intended to prevent births within the group. 2. Unanimously, the Republic of the Union of Myanmar shall, in relation to the members of the Rohingya group in its territory, ensure that its military, as well as any irregular armed unities which may be directed or supported by it, and any organizations and persons which may be subject to its control, direction, or influence do not commit any acts described in point 1 above, or acts of conspiracy to commit genocide, of direct and public incitement to commit genocide, of attempt to commit genocide, or of complicity in genocide. 3. Unanimously, the Republic of the Union of Myanmar shall take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 of the Convention on the Prevention and Punishment of the Crime of Genocide. 4. Unanimously, the Republic of the Union of Myanmar shall submit a report to the court on all measures taken to give effect to this order within 4 months, as from the date of this order, and thereafter every 6 months, until a final decision on the case is rendered by the court. I shall now call on the registrar to read the operative part of the order in French. You have the floor.
Merci, Monsieur le Président. Par ces motifs, la Cour indique à titre provisoire les mesures conservatoires suivantes. 1. À l'unanimité, la République de l'Union de Myanmar doit, conformément aux obligations lui incombant au titre de la Convention pour la prévention et la répression du crime de génocide, prendre toutes les mesures en son pouvoir afin de prévenir la commission à l'encontre des membres du groupe Rohingya présents sur son territoire de tout acte entrant dans le champ d'application de l'article 2 de la Convention, en particulier a. Meurtre de membres du groupe, b. Atteinte grave à l'intégrité physique ou mentale de membres du groupe, c. Soumission intentionnelle du groupe à des conditions d'existence devant entraîner sa destruction physique totale ou partielle, et d. Mesures visant à entraver les naissances au sein du groupe. 2. À l'unanimité, la République de l'Union du Myanmar doit veiller à ce que ni ses unités militaires, ni aucune unité armée irrégulière qui pourrait relever de son autorité ou bénéficier de son appui ou organisation, ou personne qui pourrait se trouver sous son contrôle, son autorité ou son influence, ne commette à l'encontre des membres du groupe Rohingya présents sur son territoire l'un quelconque des actes définis au point 1 ci-dessus, ou ne participe à une entente en vue de commettre le génocide, n'incite directement et publiquement à le commettre, ne se livre à une tentative de génocide ou ne se rende complice de ce crime. 3. À l'unanimité, la République de l'Union de Myanmar doit prendre des mesures effectives pour prévenir la destruction et assurer la conservation des éléments de preuve relatifs aux allégations d'actes entrant dans le champ d'application de l'article 2 de la Convention pour la prévention et la répression du crime de génocide. 4. À l'unanimité, la République de l'Union du Myanmar doit fournir à la Cour un rapport sur l'ensemble des mesures prises pour exécuter la présente ordonnance dans un délai de 4 mois à compter de la date de celle-ci, puis tous les 6 mois jusqu'à ce que la Cour ait rendu sa décision définitive en l'affaire. Merci, Monsieur le Président.
Thank you. Vice President Shue appended a separate opinion to the order of the court. Judge Cansado Trinidad appended a separate opinion to the order of the court. Judge Ad hoc Kress appended a declaration to the order of the court. The text of the order is available from today in TypeScript. It will be available shortly on the court's website. The printed text will be available in due course. As the court has no further business before it today, I declare the sitting closed.